The Senate Judiciary Committee hearing room was packed to the brim with journalists, aides, senators, and staffers, all vibrating with a sense of electric anticipation. The day had been scheduled as a routine Supreme Court oversight hearing, the kind that usually disappeared into CSPN archives without ever trending on Twitter. But this day was different. As former Florida Attorney General Pam Bondi stepped into the chamber, a wave of camera flashes ignited like a lightning storm. Her navy blue blazer cut a sharp silhouette against the burnished oak panels of the historic room. She walked with quiet purpose, her heels clicking with rhythmic precision until she reached the witness podium. Without a flicker of hesitation, she adjusted the microphone and looked directly at the senators arrayed before her. "Thank you for the opportunity to speak today," she began, her voice firm and composed. "I appear before this committee with evidence that could fundamentally alter what we think we know about Justice Amy Coney Barrett's confirmation process." A collective murmur swept across the room. Even before she pulled a folder from her briefcase, a thick, sealed envelope marked confidential in bold red, the atmosphere shifted from formality to dread. Across the chamber, Justice Barrett sat stoically, her features composed in that practiced, judicial calm. But when Bondi opened the folder and began to speak, that calm flickered. Bondi continued. "The documents I've brought with me point to a private arrangement, one never disclosed to this committee or to the public, made in the days leading up to Justice Barrett's confirmation in 2020. Barrett's posture stiffened ever so slightly. Her eyes, usually unreadable, betrayed the faintest sign of alarm. Senators leaned forward in their seats, staffers whispered urgently into phones. The chairman reached for his gavel, but he didn't strike. It was too late. Bondi placed the first document on the overhead projector. An email, dated September 18, 2020, 3 days before Barrett's nomination, lit up the room's monitors. Though vague, the message suggested that certain understandings had been reached about Barrett's stance on controversial legal issues. She wasn't copied on the exchange, but the implication was unmistakable. Justice Barrett cleared her throat and leaned into her mic. "These emails, if authentic, do not include me as a recipient. I never participated in these discussions." "That's true," Bondi acknowledged. "But the next document speaks directly to your involvement." She revealed a calendar entry showing a private, off-record meeting between Barrett and 2 senior administration officials, the same individuals from the email chain. The date, September 19, 2020. The chairman tried to intervene. "Miss Bondi, calendar entries are speculative." "I understand, Mr. Chairman," she cut in, her tone crisp. "That's why the third document is more important than all the rest." The next page was a memorandum. Written by one of the attendees, it outlined topics discussed during the meeting, including potential Supreme Court cases, and described Barrett's general alignment with key legal interpretations. One line sent a ripple through the room. Mutual commitments were discussed to ensure consistency on matters of executive authority, reproductive rights, and religious exemptions. Barrett's knuckles turned white around the edge of the desk. Senator Josh Hall, until now silent, spoke up. "Justice Barrett, did this meeting occur?" Barrett paused. "I met with many officials during the nomination process. I can't recall the specifics of each conversation, but I never made any commitments on future cases. That would violate every principle of judicial ethics." Bondi pressed harder. "Please review page 5. It contains a note allegedly written in your own hand." Barrett took the paper, and for the first time, her face changed. Recognition. The note, projected on screen, was written in neat, tight cursive, unmistakably hers. 3 key topics were listed, each marked with asterisked annotations. Xenophon 1 to 3. Gasps echoed through the gallery. The chairman called a recess. Barrett stood, flanked by her legal team, her expression unreadable. The tension in the hearing room had boiled into a moment of national crisis. The foundations of the Supreme Court, or at least public faith in it, were beginning to tremble. Outside, cable news networks broke into programming with breathless headlines. Breaking, Bondi accuses Barrett of hidden deal before confirmation. Explosive documents shake Supreme Court. Ethics crisis on the bench? Inside, As aides scrambled and senators regrouped, no one could predict what would come next. But everyone, left, right, or center, understood one thing. The Supreme Court's reputation, and perhaps its very legitimacy, now hung in the balance. The recess did little to calm the storm inside the Judiciary Committee hearing room. Staffers whispered frantically in corners, phones buzzed nonstop, and senators huddled in partisan clusters, Democrats openly stunned, Republicans poker-faced, and stone-silent. The air felt thinner, tighter, like everyone was holding their breath. When Justice Amy Coney Barrett returned, a subtle transformation had taken place. Her tailored jacket was buttoned to the collar. Her jaw set. Her legal counsel handed her a small folder and murmured something under his breath. Whatever had passed in that private room during the recess had not broken her. It had prepared her. "Mr. Chairman," she said firmly as the room fell silent again, "I'd like to address the committee before further questions." The chairman gave a slow nod. "Proceed, Justice Barrett." Barrett stood. Her voice was calm, but steely. "I've reviewed the documents presented by Ms. Bondi. Some include my handwriting. Others refer to events I may have attended. But let me be clear, I do not recognize the memorandum presented today, and I reject its characterization of any meeting I participated in during my nomination process." Bondi didn't blink. She had expected Barrett's denial. "Justice Barrett," she interjected, "the handwritten note you acknowledged includes phrases like maintain senf on points 1 to 3, phrases that align with confidential case categories referenced in the memo. Are you suggesting this was not connected to the meeting in question?" Barrett didn't flinch. "That note is from my personal preparation materials. I used shorthand for internal matters I was advised not to discuss publicly, issues tied to previous clients, privileged communications. The word senf referred to confidentiality, not confirmation. It's standard practice." Then, calmly, she reached into her folder and removed several nearly identical pages. "These are my prep notes. You'll find dozens of them. All in my handwriting. All using the same system of markings." The committee clerk took the pages and began comparing them to the one projected on screen. Senators leaned forward, scanning the documents side by side. The resemblance was undeniable. Barrett's explanation, however convenient it seemed, was, at least for now, consistent. But Bondi wasn't finished. "Justice Barrett," she said, "you claim not to remember the meeting described in the memorandum. But we have a sworn statement from a whistleblower who says they were in that room. They corroborate what was discussed, including your request for confidentiality." Gasps again. Barrett's expression didn't move. "I'd like to know who this whistleblower is," she said, her tone sharpened. "They've requested anonymity," Bondi replied. "They fear professional retaliation." Senator Ted Cruz leaned forward. "Ms. Bondi, are you seriously asking us to consider explosive accusations based on an anonymous source? Without contemporaneous notes? Without recordings? Without even a verified timeline?" Bondi was ready. She produced 2 affidavits from digital forensic analysts who had examined the documents. The metadata confirms authenticity. These weren't created yesterday. They show creation dates consistent with the timeline of Justice Barrett's nomination process. Barrett raised an eyebrow. "Mr. Chairman," she said evenly, "may I respond?" The chairman nodded. "During the recess," she said, "my legal team examined the metadata of the memorandum Ms. Bondi submitted. It was created last month, not in 2020. The software version, timestamp signatures, and file properties all reflect recent creation. That is not speculation. That is digital fact." Shock ricocheted around the room. Bondi's eyes darted to her aide behind her, whispering furiously. Justice Barrett stepped forward. "Furthermore," she continued, "on the date this alleged meeting took place, September 19, 2020, I was delivering a lecture at Notre Dame Law School. That event was live-streamed and attended by over 200 students and faculty. Here is my travel itinerary, campus access log, and a time-stamped video of the lecture." She handed the materials to the committee clerk. "And the 2 officials I allegedly met with," she added, turning slightly toward Bondi. "One was speaking at a policy conference in Tampa. The other was photographed attending a private donor dinner in Houston. Both of their public schedules are easily verifiable. Bondi's posture stiffened. She didn't respond. Senator Hall, who had earlier pressed Barrett with concern, now folded his arms, his gaze fixed on Bondi. "You're saying the documents we're reviewing are based on an impossible event?" he asked. Barrett didn't gloat. She simply nodded. "I believe Ms. Bondi acted in good faith. But whoever supplied these documents either manipulated real materials or fabricated them outright." There was a beat of silence so thick it felt like physical weight. The momentum of the hearing had shifted. What had started as an aggressive challenge to Barrett's integrity was now unraveling before everyone's eyes. The room had gone from anticipation to accusation, and now, unmistakably, to something else. Bondi, to her credit, didn't retreat. "I received these documents anonymously. I consulted experts. I verified what I could. If there are discrepancies, then yes, they need to be investigated further." She straightened. "But don't mistake my actions for malice. The American people deserve transparency, even when the questions are uncomfortable." Barrett looked directly at her. "And they deserve facts, not shadows." The hearing concluded 45 minutes later, but no one left the room unchanged. Outside the chamber, reporters clustered like wasps, cameras blinking in the afternoon sun. The headlines were already being written. "Justice Barrett refutes bombshell accusation with verifiable evidence." Bombshell busted? Experts dispute Bondi's evidence timeline. Supreme Court scandal? Or political setup? Inside, the committee staff was already reviewing the metadata. The FBI had been quietly contacted. And somewhere, out there, the so-called whistleblower had just become the center of a growing federal investigation. By the following morning, the Bondi-Barrett confrontation had transcended the Judiciary Committee chamber. It was everywhere. Cable news anchors interrupted foreign policy segments to analyze the unfolding drama. Podcasts dedicated emergency episodes. Think pieces sprouted like weeds across the internet, some defending Pam Bondi's motives, others celebrating Amy Coney Barrett's cool dismantling of the allegations. On Capitol Hill, aides scrambled to draft statements as the story consumed the news cycle. But as the noise outside intensified, inside Washington's power corridors something quieter, and far more consequential, was happening. The Senate Judiciary Committee's leadership, both Democrat and Republican, issued a rare joint statement by midday. The committee is launching an immediate investigation into the origin and authenticity of the documents presented during yesterday's hearing. Regardless of political differences, we are united in our duty to protect the integrity of our judicial institutions. It was a clear rebuke, not only of the documents, but of the chaos their introduction had unleashed. Meanwhile, the FBI's cyber forensics team, contacted quietly that evening, had begun their review. And within 72 hours, the results were in. The documents were partially authentic, but heavily modified. Several files had originated from real government templates, including legitimate letterheads and digital stamps. But the damning details, the meeting summary, the memorandum outlining mutual commitments, the supposed handwriting page, had all been altered recently. Metadata confirmed creation dates in the past month, and comparisons to earlier versions revealed copy-paste fabrication. Most damning of all, the whistleblower's background didn't check out. Not only had the individual never worked in the department they claimed, they had falsified credentials entirely. Pam Bondi, appearing again on cable news, was no longer confident. This time, her tone was cautious, almost defensive. "I acted on what I believed were credible materials, verified by digital experts. If someone deceived me, if I was used, I want that exposed more than anyone." Still, the damage had been done. To Barrett, to Bondi, to the fragile trust Americans placed in their courts. Barrett, for her part, remained composed, issuing only a single statement through the Supreme Court's Public Affairs Office. "The strength of our judiciary lies not in its insulation from criticism, but in its transparency and fidelity to law. I remain committed to both." But the story didn't end with exoneration. Instead, it sparked something bigger. 2 weeks later, in an unprecedented step, the Supreme Court quietly announced new internal reforms. Justices would now document all meetings with executive officials prior to confirmation. Substantive discussions would be logged and retained by a neutral court liaison. A new code of conduct for Supreme Court nominees, long discussed but never implemented, would become standard. The court, without directly referencing Bondi's failed case, had taken a rare step toward structural transparency. In an interview with The Atlantic, a senior justice, speaking anonymously, explained, "It shouldn't take a crisis to fix broken windows in our institution. But if that's what it takes, then we fix them." As for Pam Bondi, she faced a formal inquiry by the Florida bar and mounting pressure from her political allies. Some accused her of recklessness. Others quietly praised her for forcing a long-overdue conversation about ethics at the nation's highest level. She gave one final interview, not to a partisan network, but to a national Sunday morning program. "I didn't come to Washington that day to destroy someone's career. I came to ask questions I thought no one else was asking. Maybe I was wrong. Maybe I was misled. But if this moment brings change, even through failure, then it wasn't in vain." And perhaps she was right. Because 6 months after the hearing, Justice Barrett authored the majority opinion in a landmark case involving religious liberties, and her ruling broke sharply from the assumptions laid out in the falsified documents. It was a nuanced, independent opinion, both praised and criticized across ideological lines. But no one could say she had been bought, or promised, or programmed. In a twist worthy of the drama itself, the failed attempt to undermine her had become the clearest proof of her independence. And in a time when outrage moved faster than evidence, when lies could circle the globe before the truth had time to log in, that mattered. It mattered a lot.